My name is Adib. I'll be talking about the case of Amaruddin bin Amaruddin Lawan Ram Talib bin Jani Muhammad Alan. In this case, actually, it's the case of trespass to goods. And it can be seen that in this case, actually, there were 6 defendants. There were the former family of the divorcee, that is the plaintiff wife, that is Fadrin. And in this case, there were actually elements of specific thoughts, such as elements of assault, battery, and wrongful confinement, and even trespass to good. And there was actually choking and all those, which show there is battery and all those. And this happened because of a family issue arose. And the case actually shows there was trespass to good when defendant 1 and defendant 4 damaged the plaintiff car, such as hitting the plaintiff car and even using the helmet to damage the plaintiff car. Well, the issue of law is whether that there is specific thoughts that is committed, such as assault, and mainly here is about trespass to goods here in this case, whether trespass to goods have been committed. And the law regarding in this case is that the defendant, to especially the trespass to good, defendant must have intention of doing it, that is dealing with the goods, and even defendant has direct interference with the goods, that is the act done by the defendant to have the immediate physical contact with the plaintiff goods, such as the moment where the defendants actually hit the plaintiff car, that is showing there's direct interference, and also there is intention that they wanted to hit the plaintiff car. As a conclusion of this case, the court found that the argument of the defendant was invalid, because the defendant was arguing that the car was actually blocked, and the plaintiff actually hit the brakes. Therefore, it was reasonable for them to hit the car. And the recorded P6 actually showed it otherwise, because the recorded P6 showed the car wasn't obstructed and the plaintiff's side mirror was damaged. Therefore, it was actually invalidating the defendant's argument. But the ratio decider of this case is that hitting the car or damaging the car actually constitute into trespass to goods. And obviously, the decider of this case, the other things that I said is that even the slight touching of the car actually constitutes into the meaning of trespass to goods, as the court look at the general meaning of trespass to good. The recommendation of this case is that evidence collection must be strengthened to actually be used in court, and even counselling should be forwards used in should be implemented, as counselling actually stop issues such as these from erasing to going to court cases. That's all.
Okay, my name is Jishwa. I'll be talking about the case of Kemala Kadiula and Resmart Precious Metals and Embedded and others. This is a case about conversion. In this case, the plaintiff discovered that her daughter Tiba took the jewelry from a safety deposit box without permission. Tiba intended to give the jewelry to Satis, a man who she only knew through Facebook. When Satis failed to meet her as promised, the first and second defendants approached her, claiming Satis was ill and sent them to collect the jewelry. Touching them, Tiba handed over the jewelry. She later found herself blocked by Satis. The first and second defendants then sold the jewelry to third defendant, a Gosmi company in Selangor. Rather than the plaintiff claimed for theft of conversion against the first, second, and third defendant, and also the fourth defendant who is the director and shareholder of the third defendant, and as well as the fifth defendant who is the director of the third defendant also. The plaintiff should all involved for theft of conversion. Okay, so the main issue in this case is whether the defendants are liable for theft of conversion. So for the law part, let me explain what is theft of conversion first. Conversion is dealing with goods in a manner inconsistent with the rights of the true owner or person entitled to the possession. Based on the established principle of the theft of conversion, the plaintiff must prove that the following elements on a balance of probabilities to establish a case of conversion of the jewelry against the defendants. Okay, so the two elements need to be proved by the plaintiff is that the defendant's conduct was inconsistent with the rights of the plaintiff, who is the owner of the jewelry or who is entitled to the possession of the jewelry. Then the second element would be the defendant's conduct was voluntarily, deliberately and intentionally done, which is not accidental. So let's move to the conclusion of the case. The judgment of the Sessions Court was upheld by the High Court, and the plaintiff's appeal was dismissed with a cause of RM 20,000 for the cost of this appeal and the court below. The ratio decider of this case is that the first and second defendants are liable for theft of conversion because the two elements was able to be established upon conduct of the first and second defendants. On the other hand, the third, fourth and fifth defendant was not liable because upon reviewing the evidence presented, the court found that the plaintiff failed to provide evidence demonstrating that the third, fourth and fifth defendants had committed theft of conversion against the plaintiff, which means that the two elements of theft of conversion was not be able to demonstrate or established by the plaintiff. So the main reason is because the failure to meet the burden of proof by the plaintiff and also unawareness of plaintiff's ownership. And the court found that the third, fourth and fifth defendants had conducted proper due diligence. So the obiter dicta of this case is that if the third, fourth and fifth defendants was mastermind of the first and second defendants, then they will be liable for theft of conversion. For the recommendations of this case, efficient due diligence should be conducted. For instance, business must conduct thorough checks such as verifying ownership and obtaining proper identification to ensure compliance with legal standards and avoid liability. Then parties seeking for claims must ensure their claims are supported by comprehensive evidence, such as plaintiff must present clear and sufficient evidence to support their claims and to meet the legal burden of the proof.
Hi guys, today I'll be discussing the case of Chen Sayao and Diego Sanabhat 2034, the case focusing on conversion. The plaintiff Chen Sayao invested RM200,000 in Diego Sanabhat based on promises of financial stability. He later paid RM10,000 to the second defendant, believing it was linked to the lucrative project. The defendant failed to issue share or refund the investment, interfering with the plaintiff's control over his fund. The plaintiff claimed This interference constitutes conversion, which occur when someone unlawfully assumes control over another's property. The court refers in case of Yohata Mercedes and Abhat and Coinmaster and Abhat to analyze fraudulent misrepresentation and deceit which supported the conversion claim. The issue was whether the defendant committed conversion by unlawfully controlling the plaintiff fund. Under the law of conversion, there is two things that need to succeed. The first one, the plaintiff needs to show that the defendant intentionally interfered with his fund, and the second one is this was done without lawful justification. The court ruled in favor of the plaintiff, finding the defendant guilty of conversion. The judgment awarded 300,000 ringgit from the first defendant and 600,000 ringgit from the second defendant. The ratio that arises is unauthorized control over another properties, especially fund, constitute conversion when it deprives the owner of their right. The arbitral emphasizes the court emphasized the importance of the honoring investment agreement and conducting due diligence in financial transaction. The court recommendation is that the company must ensure compliance with contractual obligation and maintain transparent communication to avoid legal dispute. Thank you, everyone.
Hello everyone, let me introduce the case of Ibrahim bin Hashim against Devi Mulia Chisyasti. Here's the story. In this case, Ibrahim, the plaintiff, and Devi, the first defendant of this case, got married in the year of 2000. 5 years later, Ibrahim, the plaintiff, transferred a house in Bayan Lepas Pulau Pinang to Devi. Originally mortgaged with HSBC, the house was later refinanced by Citibank, the second defendant, after Devi's application. Ibrahim claimed that Devi made certain martial promises to him, such as remaining his wife and providing undivided love. He argued that if Devi breached these promises, he could divorce her, reclaim the house, and avoid paying maintenance fees. After their relationship had ended, Ibrahim sued Devi and Citibank for wrongful detention of the house under the Tort of Retinue. One of the cases referred to by the court in making its judgment in this case is Chang Kyo against Shari Yaqub to guide its evaluation of conflicting evidence. Let's move on to the issue and law of this case. The main issue was whether the Tort of Retinue applies to real property and whether the defendants wrongfully detained the house despite plaintiff's demand. Under law, the court clarified that retinue does not apply to real property and requires evidence of wrongful detention and refusal to return the property. Ibrahim failed to provide sufficient evidence. Devi had been the registered owner of the house since 2005 and Citibank had lawfully refinanced the house in 2014. In conclusion, the court dismissed Ibrahim's claim against the defendants and ordered him to pay 50,000 ringgit to each defendant. The obiter dictum is that the court emphasized that the martial promise claimed by Ibrahim could not be legally enforced. The ratio dissidenti is that the court concluded that the Tort of Retinue does not apply to real property, and Ibrahim failed to provide sufficient evidence of wrongful detention to support his claim. Lastly, the recommendation are it's important to seek legal advice to ensure your intentions are legally clear and gather strong evidence when bringing a claim, as without proof of wrongful detention, it is unlikely to succeed. Thank you.
I'll be continuing the presentation by presenting a case in Retinue as well. My case name is Stonewall Sendirian Berhad against Enggari Sendirian Berhad. This case is a 2020 case that was appealed in the federal court. In this case, the plaintiff, which is Enggari, is a company that produces and imports marbles and granites. And in 2008, they engaged in an oral agreement with the defendant, which is Stonewall, and they supplied stone slabs to them. However, they realized that they were overcharged and they immediately terminated the contract and demanded the defendant to return back all the stone slabs. The defendant's failure to return back the stone slabs have caused the plaintiffs to start a claim of retinue against them. The trial court then held in favor of the plaintiff, asking the defendant to return back the stone slabs to them or allow the plaintiff to take it from them. The plaintiff then sought for a consequential order to replace the delivery obligation with damages as some of the stones were damaged. The defendant then counterclaimed by saying that the plaintiff owed them certain sum of money. The High Court ruled in favor of the plaintiff, ordering the defendant to return back the stones with damages to be assessed, while partially allowing the defendant's counterclaim for the unpaid charges. However, later on, the defendant did an appeal in the federal court, claiming that the High Court and Court of Appeal lacked jurisdiction as it was functious officio. So, functious officio is the doctrine that stipulates that once a court has issued a final judgment, it generally cannot alter or revisit that judgment. The issue in this case is whether Stonewall unlawfully retained the marble and granite slab belonging to Enggari after the termination of their processing contract. giving rise to detiny liability. The other issue is whether the High Court was functius officio when it granted a consequential order modifying the remedy of its final judgment from delivery of marble stones to damages in a detiny case. The related law in this case is legally, detiny is the wrongful detention of goods which the plaintiff has an immediate right to possess. To establish a claim for detinue, the plaintiff must demonstrate that first is the demand and refusal. The plaintiff must prove that the defendant kept his goods after the plaintiff requests for its return. Next is the immediate right to possess. Plaintiff must prove that he has the rights of immediate possession over the property. The case that was referred to in bringing the judgment in this case is Tenaga Nasional Berhad against Prora Sendirian Berhad and Anur. In conclusion, or the ratio decidendi in this case, is the court clarified that the doctrine of functius officio, which prevents a court from altering its final orders, does not apply when the order is only meant to follow up on the original judgment and does not change its main decision. The court also reaffirmed that the Stonewall was liable for detinue as he had failed to comply with the initial order to deliver marble stones or allow Angare to collect them. Finally, Stonewall could not reopen issues that had already been decided due to the principle of res judicta and issue estoppel, which ensure finality in legal cases. My recommendation is to encourage the principle of finality in litigation to prevent repetitive suits that waste judicial resources. And also, the court should emphasize the liberty to apply rule in judgment to ensure parties understand their rights to seek clarification and enforcement without violating the legal doctrines like functius officio. So in short, Stonewall was ordered to pay 40,000 ringgit to Angari.